Here at the Legal Warriors, in this video, I'm going to cover a very interesting decision that some criminal defendants get to make. Do I want a jury trial or do I want a trial by judge or a bench trial? And that's something that some cases is a very important decision that can affect guilt or not guilt. So if you're interested in this area of the law, stay tuned. This is the video for you. My name is Attorney Lance Fryrear. I'm a defense attorney in Lynnwood, Washington. My law firm has been defending people charged with crimes all throughout Washington State for more than 25 years, and I'm putting out these videos to help educate the public. So if you find this useful, please like and please subscribe. More people get to see it. More people get the help they need. Now I'm just going to jump right into it. In Washington State, a defendant has a right in a criminal matter to a jury trial. Now, sadly, the prosecutor has a right to a jury trial also. I don't think they should have any rights, if you ask me. But that is a right that a defendant can waive and instead say, I don't want my case tried in front of a jury. I want it tried by a judge. And for this video, we're going to assume that the prosecutor has not put in their own demand for a jury trial. Now, some prosecutors do that routinely, but most do not. And the ones that do put it in routinely probably at some point got some ruling from a judge they didn't like, and they said, I'm going to make sure that judge never decides the trial again. And they put it in every case in their demands. But still, sometimes the prosecutor, if you want a judge trial, they'll think, man, that's a lot easier for me. I'm going to go ahead and agree to allow the case to go by trial by judge. So we want to start with, when is it that we might want to consider a trial by judge, and when is it that we more likely want a trial by jury? So if a defendant is very, very obviously guilty of a crime, the fact pattern is clear, but it's a sympathetic fact pattern. And let's say, and I've almost served on a jury in this case, believe it or not, and unfortunately the prosecutor let me off, even though I'm a defense attorney, is a no contact order violation that's like a allowed violation. So in Washington State, if there's a no contact order against you, oftentimes the protected party says, yeah, come on over, I don't care, right? And you come on over, and now the police get called for some reason, and it doesn't matter that the protected party invited you over. It's the court's order, right? It's not the protected party's order. Now, that person who was just listening to the protected party, it's okay, I don't care, they come over, they get arrested, and they're charged with a crime. Now, in that situation, a judge is going to obey the law, right? I can think of one that wouldn't, but again, the guilty shall be protected here. The judge is going to follow the law and says, hey, it doesn't matter if you were invited. The law says that that's not a defense. I'm a judge. I have to uphold the law, or I'm not going to be a judge very long, so I've got to find that person guilty. So we don't want to go to a judge trial in that situation. However, in that case, maybe a jury trial is definitely best because there's jury nullification, right? It's like, hey, that may, with the right type of sympathetic argument, stuff like that, a jury might find someone not guilty for an invited violation. And in fact, the very trial that I was almost on the jury for, the public defender wanted me out at the last second because they probably figured as an attorney I would uphold the law. That case ended up with a not guilty, even though there was an on-view violation, an invited violation. And so that case was a situation where, yeah, something with sympathy for the jury, we might want it to go in front of a jury. When might we want to go in front of the judge? Well, something where there's really a legal issue that needs to be decided by the trier of fact as opposed to the judge. And we could think about a situation where there is somebody sitting on contraband, someone sitting on a pot pipe, let's say, right? And it's not their car, though. They're sitting on a pot pipe, it's not their car, and the person who's the driver gets pulled over, and now they get the passenger out, and, oh, you're sitting on a pot pipe, you're in possession of drug paraphernalia. Well, in that situation, while we might bring a motion in front of a judge, oftentimes a judge is going to say, hey, whether or not that person was in possession is for the trier of fact, right? And in that case, because that's a legal issue and the judge has some idea about what constructive possession means or doesn't mean, we probably want that case to go to a judge trial, because the jury, they might think, oh, they're sitting on a pot pipe, they're druggies, everyone's guilty, convict them. Well, the judge hopefully doesn't have that emotion. And in that situation, they might be able to be more able to define the factual issue as it applies to the legal issue and hopefully find that person not guilty. And I've seen that case happen as well in this very office. So when you have a situation where the emotions are going to be inflamed against the suspect from a jury, that's a situation where you might be more likely to go to a judge because hopefully they won't have those same emotions. In a situation where we've got a police problem, bad police, we almost always want that to be in front of a jury because we've got now a new villain we can point out. Right? A lot of people don't like police. They do us wrong. They do our loved ones wrong. The judge has to like the police, right? All the case law says protect the police. The police, they need to get reelected, right? They don't make points in the world by saying bad police. So if we can blame the police, we definitely need a jury. If it's more of a legal issue, it's more likely we need a judge. And that's how I want you to think about it. A jury trial is not always the best because we're sitting in the guilty chair, not the not guilty chair, but also sometimes a jury trial is the best if we have someone else to blame besides the suspect, or if we have a sympathetic issue where we might be able to get jury nullification. And also remember, it's a lot more work for the prosecutor to go to a jury trial. So if we're trying to put pressure on the prosecutor who can only do so many trials at once, that pressure doesn't work if you go a judge trial. As a prosecutor, if it's a judge trial, I'm like, yeah, I'm just going to lean back and take care of this because I don't have to do anything, right? It's an easy argument because I don't have to perform in front of the judge and I have to, pick a jury and all that stuff. So buyer beware, we have to be careful, but I wanted to cover the options where a bench trial may be better and let you know it is up to you unless the prosecutor demands their own jury trial, and that's in Washington State. So I hope you found that useful. If so, please like and please subscribe. More people get to see it. More people get the help they need. More importantly, you got a criminal matter in Washington State. Feel free to reach out to our firm. If we get on board, we'll listen to what happened, we'll identify a way forward, and we will be there for you. Thank you.